Welcome back to No Kings on the Hill. Tonight, we want to discuss two topics that go straight to the core of our constitutional republic. Number one, when political activism invades a house of worship to disrupt a religious service, not to protest outside the church, but to disrupt services inside the church sanctuary itself. It's not that doesn't work. And then number two, we are going to discuss a landmark Supreme Court decision that could once again give something Americans have been told to stop expecting: fair elections, and that really nobody's talking about. Both of these topics tie together with one idea: the rule of law matters and the Constitution means what it says. So please stick around, and we will be back after a word from our sponsors.
Heard of Q Broadcast? It's taking the world by storm. People are cutting the cord to their high cable bills and moving away from streaming services like Netflix, Hulu, and others for something better. Q Broadcast. For just $60 a month, you'll get access to every channel you could ever want, including HBO, Cinemax, and Stars. And the best part? There are no contracts, no hidden fees, and you're free to cancel anytime. With Q Broadcast, you can enjoy streaming live TV, movies, and top series on up to 5 devices at once. Whether you're at home or on the go, Q Broadcast makes sure your entertainment is always at your fingertips. Imagine being able to watch all your favorite channels from anywhere, anytime, without any restrictions. We're talking about thousands of movies, hundreds of TV series, and a huge library of live channels, all in one place. And don't forget video on demand and pay-per-view events. Those are included at no extra cost, so you'll never miss a big event again. Now, take a second and think about your current cable bill. You're probably paying anywhere between $100 and $300 every month, locked into long-term contracts and hit with surprise rate increases. With Q Broadcast, that's a thing of the past. It's just $60 a month. No contracts, no extra fees, no hidden costs, and no price hikes. Why juggle multiple subscriptions like Netflix, Hulu, and cable when Q Broadcast gives you everything you need in one convenient package? People everywhere are switching to Q Broadcast, saving money and getting more content than ever before. So, what are you waiting for? Click the link in the description and sign up for Q Broadcast today. Just $60 a month, no contracts, no hidden fees. It's time to take control of your entertainment and start streaming smarter.
All right, this is No Kings on the Hill with Dr. Law and Jose and Claire JD. I'll bring my co-host up here in a minute. Over the weekend, anti-ICE protesters invaded a Baptist church during Sunday morning worship at their church in St. Paul, Minnesota. It was not a rally. It was not an outside in a protest zone. The protesters didn't stand silently in the back. The protesters disrupted worship at a church, harassed and pushed parishioners while they were with their children, and Don Lemon got up in the face of the pastor and berated him. This is not acceptable behavior. How far has our society fallen when we get to this point? Once a nation built on Christian values, now citizens can't even feel safe inside the house of God. Now, the DOJ is considering whether the activists' behavior was in violation of federal law, including the FACE Act and the Ku Klux Klan Act of 1871. Also tonight, we will discuss how the United States Supreme Court issued one of the biggest election rulings in recent memory. The court ruled that candidates can sue over election rules prior to the election under Article 3 standing. This is a significant departure from past precedent. The Supreme Court's ruling in Boss v. Illinois completely changes election integrity enforcement. Tonight, we'll explain why that ruling, the protests this week in both matter, how they interest, and why we may have just avoided another post-election constitutional crisis. Now, I'm going to start with my do a little monologue, and then I will bring up Joe, and then we will get into the meat of the show. So, what took place at a Baptist church in St. Paul this weekend isn't background noise or a culture war talking point. It is a constitutional fault line. The First Amendment doesn't protect beliefs. It protects worshipers' rights to assemble for religious purposes without fear of intimidation, disruption, or coercion. When protesters disrupt a church service to make a political point, they aren't exercising their First Amendment rights. They are violating the constitutional rights of others. That's why Congress passed laws like the FACE Act and the KKK Act to put an end to efforts to suppress others' civil and religious rights through intimidation and disruption. The rule of law is clear. You have the right to protest. You have the right to speak, but you cannot violate someone else's constitutional rights in the process of doing either. Here's why what happened this weekend matters more than one church. Erosion of our constitutional rights doesn't happen in isolation. The same people who believe churches can be disrupted at all will believe elections are just suggestions if they don't like the results. Now, I'm going to pause there because that's the end of the part with the church, and we're going to go ahead and bring Joe on, and we'll discuss that, and then I will finish my monologue on the section with Dylan with the Supreme Court president. All right, Joe, go ahead and unmute.
Hey, how are you?
Alrighty. So, I mean, I know you're big in Christian and belief, so I know that this hits home for you too. And it's like, how far has our world fallen? Like, I mean, even back in the 1970s, 80s, even back all the way to the early 20s, mobsters, gangsters, even, evil, violent people at least respected the church. Even they would not attack or do violence in a church. That's where they would meet to try to squash their beefs, because they would never do anything violent on church or church property because they know they were going directly to hell.
Yeah, I mean, it speaks a lot about a group of people or an individual. It's one thing to not have respect for another human being or another life, right? We know there's tons of people out there who abuse other people, abuse animals, but then for them to, a higher power, it shows they don't have any respect for themselves, right? This is a cult of destruction. This is a cult of hatred. This is a cult disconnected from reality. Whether or not you like Christians or not, like, you're affirmatively entering, their private, and I'm not saying safe spaces need to exist, but that's private property. It's church property. They're not harming anyone. I just don't understand what the thought process going into this was. What optics, who were they trying to reach and motivate by doing this, right? This can only alienate them.
Oh, yeah. No, I was just replying back to the comments. Somebody was asking, like, why we were ignoring them, and I was like, we're not ignoring. Okay, people, sorry. Just this is a lot of topic, but if we do not answer your comments or reply right back, it's because there's only two of us. We don't have a team of people that are back there monitoring and doing stuff like that. The majority of the time that you see podcasters just constantly doing replying to the comments, it's because they have a team that's actually replying and answering to those, and then in their ear saying, hey, we've got a question or a comment from so-and-so. Would you like to take it? We don't have that. So obviously, as you can see,
I think that girl was trolling because she said she was talking about relationships. I'm pretty sure she said, "What do you do when you show guys attention and they don't?"
Yeah. Okay. And that's also, if you're going to sit there and try to troll and talk about relationships versus God, we're not going to reply to you. We're only going to reply to people who actually offer intelligent and it will actually give to the show or make the show better, or it has to do with what we're talking about. We are not here to go off topic down a bunch of rabbit holes. We are not here to talk about Trump. Our title does not say Trump. Our title said Christianity and religious freedom, and then Supreme Court president and voting laws. So that's what we're going to stick to. Doesn't mean we won't mention his name, but that is not the subject. But yeah, I mean, it just shows you how bad and how far these people have gone, and that they don't even care about religion anymore. They don't care about the sanctity of worship or family or anything like that. And they try to say that they're the accepting ones, that they're the good ones. But yet the people are in there with their families, and they're sitting there yelling and cursing and getting up in these people's faces with their little kids right there beside them. Now, if they have a right to protest in the First Amendment, yes, but they have a right to either one, stay outside and protest, or two, they could have stood in the back of the church with signs silently. That would not have been obstruction. That would not have been violating any law. But because they came in there and stormed in, trying to stop people from leaving, berating them, pushing them, getting up in their faces, not allowing them to be able to hear what the pastor was saying or listen to him, or and engage in their sermon or allow the pastor to actually give the sermon and to speak to his parishioners, there is that right there became a violation of the second part of the First Amendment's constitutional right, and that is the freedom of religion. So this is a people trying to practice their First Amendment right while also violating other people's First Amendment rights, because it's the right to freedom of speech and the right to the freedom of religion, and you can't violate one right. You can't use one constitutional right to justify violating another.
Well, one is a right, the other is not a right, right? So let's not confuse those. Like, you have the right to protest, you don't have the right to enter in, and even yelling at somebody is a form of assault under most statutory state law. So again, the thing I see here is that we talked about this the last week, where they've created the conditions for Trump to react and send in ICE. Said, it's a self-fulfilling prophecy. Trump's going to round everybody up, right? This is what they've been saying for the last 4 years. Yet they create the conditions that he has to send in the National Guard. And then when that's not working, then they start going into churches and they start disrupting churches. And it's completely projection. It's DARVO, right? Deny, attack, reverse, victim, and offender. This is psychology speak, and they love this. And they like to talk about speaking truth to power and getting in people's faces. And how is it that regular people going to this is not a huge mega church, right? This is a normal sized church. Most of the attendants, most of the participants are not rich people. It's not an institution of power. These are not people that are wealthy and that have power and that they're deciding things. What you're doing is you're attacking the weakest link. You're attacking the lowest hanging fruit, the easiest target, because you know that there's nobody there who's going to defend them. So all these tactics that they accuse of, quote unquote, the far right or the alt-right or whatever the new terminology they want to use, it just shows that the only thing these people think of is the world in terms of power, domination, and submission. And maybe perhaps they grew up in a majority Christian America. I know things have shifted now. Perhaps they were gay. Perhaps they were, not accepted by their Christian parents. And perhaps they pushed away God and said, F you to God because of what other human beings have done to them. But they're really just condemning themselves, because as they do this, and we're going to talk about this, they're availing themselves. They have criminal culpability and liability. And it's, how are you going to vote in an election when you're all being charged with felonies? Is that the goal? Or Soros going to put out the money to get you guys out of trouble once again?
Oh, yeah. No, I got you. And yeah, it's just ridiculous. And it's funny that Don Lemon thinks that, because he's, I was just acting as a journalist or whatever. No, the thing is the only reason he did this, he went there, is because he used to be this big, huge, he's a narcissistic attention whore, and always wants to be the center of attention. The world revolves around him. And because he got kicked off CNN, nobody even really knows who he is anymore. He's feeling like he's got to make himself relevant. So he was
on TikTok. He was on TikTok begging for galaxies a year ago. And then what qualities, what virtue does Don Lemon possess? Okay, he's gay. Like you said, he's more of a narcissist or a sociopath than me, because his actions have spoken louder than his words. He can talk about speaking truth to power, defending the weak and vulnerable, but he is in a position of power. He's a rich elite. And you know what else? Like, he's using his gay identity to put himself in this victim class that he can carry out acts against other people, right? This is not what our country is founded upon. This is not, and let's not forget who Don Lemon is. He got accused and he settled because he sexually assaulted a man in 2019. So this isn't some virtuous guy. This isn't and yet they continue to choose these individuals as those who represent themselves. And I get it. People make the same criticisms against Trump. But in this case, this is actually a concrete, settled actual thing that he had to admit to.
Oh, yeah. And the thing is this, he doesn't care about the $10,000 fine. And obviously with I forgot about that charge. So he might actually get the full 6 months in jail. The judge may not get him off. If he had never had that issue and he had just been a law-abiding citizen, done good stuff and everything, the judge might have said, well, hey, if you donate some money to this nonprofit, we'll waive the 6 months or whatever, give you probation instead of jail time and the $10,000 fine. But with him having that previous criminal background or whatever, then hopefully he'll get that whole 6 months time frame. Now, if he can get convicted under both of the acts, the FACE Act and the KKK Act, then that's a different story. And so that brings me this. I'm going to go ahead and bring us to our
just to be clear, his charges were dropped after after I guess he settled with the accuser just to get things, but he was charged. So
okay, yeah. So people, just for y'all that don't know, the FACE Act is it makes it a federal crime to use force, threat of force, or physical obstruction to interfere with access to reproductive health services or interfere with the free exercise of a religion at a place of religious worship or damage or destroy the property of a place of a religious worship. Critically, Congress explicitly included churches and religious worship in the statute, not as an afterthought, but as a parallel protection to clinics. So key statutory definitions are interfere with, restricting freedom of movement, intimidate, placing a person in reasonable apprehension of bodily harm, physical obstruction, rendering ingress or egress implausible or unreasonably difficult or hazardous. The statute does not require violence. Non-violent physical obstruction is sufficient for liability. Now, application to the St. Paul, Minnesota church, this is where it applies to it, based on public descriptions of the incident, disruption of worship services, entry into the church, intimidation of congregants and clergy. If protesters acknowledgedly entered the sanctuary or interior space, disrupted an ongoing religious service, blocked entrances and exits, intimidated worshipers or clergy, then those actions squarely fit under U.S. 248A2, interference with the free exercise of religion in a place of worship. Now,
can I make one real quick point about that? So broadly under criminal law, too, we have this expectation of what a reasonable person might do, right? And essentially in any of the statutory guidance across the entire U.S., if you're doing something to physically block somebody, or you're doing something that a reasonable person would think, I can't leave, or I must use force to leave, right? Because in many states you have stand your ground. Other states you have, the duty to flee, the duty to disengage. So if you've put yourself in a position where the other person reasonably would respond in a way with violence or force in order to let themselves escape the situation or to remove you from the situation you've created, then you're criminally culpable for every, chain of event, every crime, even the other person commits, you could be culpable for. So their manipulative tactics aren't working, but they're doing the thing where they step it. It's like a bully putting their fist right beside your face, saying, "Don't touch me," right? And you go like that, and they go, "Oh, you hit my hand." Like enough people have tried this throughout the history of humanity that these loopholes aren't going to work for them if they're actually charged, right? If they're actually charged, which let's hope they are.
Yeah. Okay, so now DOJ charging theory under FACE Act. The Department of Justice would need to establish intentional conduct, physical obstruction, intimidation, or interference, targeting religious exercise at a place of worship. Now, we know they're going to be able to do that. Applicability to Don Lemon legal threshold. Don Lemon could not be charged merely for speech or presence. However, FACE Act liability can attach if prosecutors could establish that he directed, coordinated, encouraged, or materially assisted the interference and did so with knowledge and intent that religious worship would be obstructed or disrupted. This would require evidence beyond commentary, such as planning, signaling, logistical coordination, or on-scene direction.
Which there is.
Absent such proof, then First Amendment protections would apply, likely bar prosecution, but we've got cameras showing that. So now the other act you hear everybody talking about, which was actually called the Enforcement Act. Go ahead. You can go ahead, Joe.
Just scroll back up real quick. Just that last. Yeah. So again, even in criminal law, so there's two things I want to highlight is that circumstantial evidence. You notice how it's talking about commentary, beyond commentary and speech. Other circumstantial evidence exists, and that's going to be his text messages. It's going to be the level of communication that he had with the group that coordinated this. If he knew, then he could be charged with conspiracy, right? Because if you know something's going down, we have these catch-all conspiracy charges. Like if you're in the getaway car before a crime occurs, and you say, "I didn't know they were going to do that," probably not going to fly. You're probably still going to be convicted as aiding and abetting a criminal and being part of the conspiracy that they undertook. I also want to highlight the language right there. Material assisted. Material assistance is not material. Federal courts have ruled that if you, let's say, donate to someone, if you translate for them, if you provide them directions on your phone, right? If you are, that's the establishment of material. So don't get confused and think that he has to actually be giving somebody something. As long as he's facilitating their actions, which clearly he did. And I think even the fact that he was there present filming it is in a way emboldening them. And again, I think he's already dead in the water on this, but if this was like if this became some sort of legal gray area, then that would have to play out in court. But I just don't see, unless he has a very favorable judge or jury at that time, he's going to have to play on that.
The only way I could think he could have maybe gotten out of it is he could have claimed he was a journalist, but that would have only worked if he had stayed in the back filming, not leading the crowd, not up at the front berating the pastor. Ask him if he had been outside and just filmed it from back at the back of the pews with the camera, and then whenever everybody started walking out, then he tried to ask the pastor questions. That would have been a different story. He could have maybe declared that it was protection under journalistic standards or whatever, but he violated all that. So now let's get on to the other act, which
Can I throw one more thing? Can I throw one more thing in there? So again, this is like the Jesse Smollett case, right? I'm sure Don Lemon knew that his actions were going to result in some sort of legal repercussion. But in his mind, he did the calculus. He said, am I going to get more in trouble from doing this or from me not entering the news cycle, right? Because this is a guy that's fat. I looked him up. He's on Good Morning America. So we have these representations in our society in the past, and I'm not talking religiously. I'm talking kind of from the perspective of analyzing society, right? In the past, we had the Roman gods, and they represented the different values or virtues. And today, we don't have these demigods. What we have is celebrities. And people like Jesse Smollett and Don Lemon, who are, this is an insane set of actions. But the truth is, he's probably going to profit from this because of the controversy. His name's back in the public square. And at least 30% of the population, because they vote blue no matter who, are going to get right behind him, support him, no matter what. And I think that's sad. Sorry, let's get back in the legal analysis.
Right. So now let's go back to what's actually were known as an enforcement acts, but they ended up being called the KKK Acts or the Ku Klux Klan Acts of 1871 that you've been hearing being floated around. Now, I believe this is going to be a little bit harder of a bar or threshold to meet. I think we definitely got him on the FACE Acts. After I actually read the legal part of it, not just if you just read the Ku Klux or the enforcement acts, like the policy and the law itself, it's not as clear. But when you do this and you go and you research the actual how it's been ruled and how judges or the Supreme Court have ruled it, it's a little bit better of a chance. But pretty much what they are is they were enacted to enforce the 14th Amendment and suppress organized conspiracies that deprived citizens of constitutional rights through intimidation or violence. The April 1871 Act, commonly called the KKK Act, targets conspiracies to deprive persons of equal protection or equal privileges and immunities through intimidation, force, or coordinated action. So elements required under 1985-3 to proceed criminally or civilly, the government must show a conspiracy of two or more persons, intent to deprive a protected right, overt acts in furtherance of the conspiracy, and resulting injury of deprivation, class-based and individually discriminatory animus as interpreted by courts. This is a high evidentiary bar to hit, but like Joe was just talking about a minute ago, conspiracy. Now, application to the church invasion scenario, the KKK Act theory would be far more difficult than a FACE Act charge. Potentially viably exist only if prosecutors could show coordinated group action, targeting a religious congregation as a class with intent to suppress constitutionally protected religious exercise through intimidation of force. So this is where it comes in. Can they show that they actually meant to go? They went to that church specifically because it was a church, and to interfere with their ability to practice their sermon.
So let's look at B and C because I want to highlight something real quick. Can you go back up to B? Can you just scroll up there? Okay, so you see the elements required under. So each element is a separate element, right? So if I was a lawyer, either defending or trying to prosecute this guy, I would look at each element of the crime and I would say intent, and then I see overt acts, right? So overt acts to provide, or overt acts and further into the conspiracy. So yeah, that is a difficult thing to prove if you don't have the evidence, which even on camera, that this is going to be more difficult to prove. However, because the statutory guidance says, and the statutory language says intent to deprive, it doesn't say overt intent. So what we can, there's circumstantial things we can understand by what took place. And there's another term we use is tacit, right? It's where you don't overtly say something, but let's say, you're going on a date and you lean in to kiss. You're not going, hey, will you kiss me? There's a tacit understanding. We just went on a date, we're getting closer. So scroll back down one more time. So by virtue of, let's look at all these different actions. Coordinated group action. Do we know there was a coordinated group action? That was overt, clearly. Targeting a religious congregation or class. That would have to be with intent. So that's not overt. That could be unsaid. And the fact that a church was targeted, that in itself is enough to prosecute on this. Now, the real hard thing that they're going to have to hammer out is the intent to suppress constitutionally protected religious exercise, because that is a harder element to prove than, specifically just targeting the church. They have to say they were targeting the church to prevent the church from carrying out these actions, right?
Yeah.
And then obviously we see intimidation. I think that was very intimidating for anybody there. Again, that's surface level, but it's that third prong in this application that's going to be their hang up.
Yep. And so real quick, please, everybody that's in here, tap those screens, like, subscribe, follow, hit that notification bell. Let's try to get the engagement rates up. So hopefully they'll YouTube or whatever's algorithm will push this out more. Try to get some hype points going for us there. And also we go live. I go live every day on TikTok. If you want to jump on there, go to our website, No Kings on the Hill with drhillaw.com, and all of my social media tags are there. You can follow me, and also you can help give suggestions of what y'all would like to see us cover content wise and stuff. I am working on hopefully getting to have an interview with a congressional candidate for the 35th district in the state of Texas here in the next week or so. And then also on March the 25th to the 28th, we will be broadcasting live from CPAC this year. So that's going to be a nice thing. Who we will get to interview, that will be another question. I'm sure we'll get to probably interview Matt Schlapp. I found out we actually are getting press passes. So while I may not be able to show it live, but I may actually get a chance to ask Donald Trump or Vice President Vance a question or two. I won't be in front of the camera because obviously it'd be in the press pool, but we'll see what's going on there. So yeah, and this is where, like he said, is Dom Lemon exposure under the KKK Act, charging a media figure under 1985 require proof that he participated in or knowingly furthered a conspiracy and shared the intent to deprive constitutional rights and acted with class-based animus. Absent direct evidence of conspiracy participation, prosecution would be extraordinary unlikely, and that's what I've been saying. So I'm not my doctorate is in law and policy, more on the administrative law side, more on the constitutional and stuff like that. So, but I still have a basic understanding of the criminal law system and stuff, and I can understand the language, and that's what I was pretty sure of. I just don't understand all the other stuff you have to equal. And then also I always tell people you have to be careful about how they word stuff. Is it and or is it this? Is it option A or option B, or is it option A and option B? Because that's where they get you. Sometimes they could list 5 things that could charge you a case, and they could say this happens or this happens or this happens or this happens or this happens, which means it can be you only need one of those. Or it could say this happens or this happens and this happens or this happens and this happens, which means then you need to equal 2 of those, be able to get the case. So you really have to be, I see all these people trying to be armchair attorneys and everything. You've got to be really careful how you read stuff. You've got to look at those adjectives and the connotations and the nouns and the adverbs and all the linking verbs and all that, because that's really what tells you what you actually need to do. But so evidentiary burden, we'll kind of go with this. So the FACE Act, viability high, evidentiary burden moderate, best use cases, church disruptions, intimidation, obstruction. KKK Act, 42 USC 1985, viability low, evidentiary burden very high, organized conspiracies targeting protected classes. Enforcement Acts, general, limited, evidentiary burden high, systematic suppression of federal rights. So what I'm looking at is, and this is another thing I was thinking of, is when it comes to what, dang it, now I forgot what I was going to say when it came to looking at those cases, and I lost my train of thought there for a second. But yeah, so pretty much.
I'll just add on to one of your last points regarding like how law is brought together and kind of contrived, is that when you think of law, right, it's the balance of justice, right? You have these inputs and the outputs. And before you go to law school, the first thing you should study is logical proofs. So they teach you the formulaic language of essentially how to break words out and say and or, and they teach you the symbolism for them, so that just like in the goal of our justice system, at the end, you have an equal equation, right? Something that produces the outcome where everyone's in harmony, right? Someone did something wrong, there is, remedial action taken, or they pay that person based on whatever tort or harm came to them. So it is very formulaic. And half of knowing how to read legal statutes is just knowing, okay, does this language indicate like an and or? That's just so wide open, right? Because it could be and or. But if you say less than, they say less likely, then you would think, okay, that's 20, 30%. No, that's anything 49% down to 0%, right? And that's the same on the opposite end. Hopefully you remembered what you were going to say. I was just trying to kill time for you.
No, we probably just get on to the other things. I was trying to look over going at the different acts and stuff, but yeah, I mean, we pretty much solved that. That's what, now I remember. Okay, so on the FACE Act, it's also a civil or prosecutory or criminal. So that's the question of, do we think is this going to be, will they be able to equal the charges of criminal? I mean, just civil or civil and criminal? Because it's, the actual bill reads, hold on a second, I'll pull up the actual bill on it, but the actual bill for it on the FACE Act reads a total different aspect on what the two different charges are. So it can be, I was trying to think of the words of what you call for civil, and then the legal word for criminal. It starts with a P.
Punitive?
Yeah, punitive. So it's the civil or punitive damages. So it does allow for civil and criminal. I'm just a question of, do you think they can equal the criminal charges here versus just the civil damages? I mean, wouldn't civil just have been if there was destruction of property or something like that? Wouldn't that have been your main civil damages, since this was more of threatening and yelling and obstructing? Wouldn't this be more of a punitive damage situation?
That'll be state by state based on the state tort law.
Well, it's a federal crime, so it's
within those federal statutes, they're gonna delineate, because in a criminal case, like a defendant could be required to pay reparations to a victim, right? XYZ amount. But in a criminal case, that's usually not going to be anything pain and suffering, right? That's going to be an injunction or cease and desist, perhaps. If Don Lemon had gone and chained the front of the church and he put a lock, he'd be ordered to remove it. Okay, that's very unlikely. That would be if the state or local government was doing something like that. But as far as like on the civil side, I mean, they could sue civilly based on, pain and suffering. Sure, there's not a whole lot of civil damages or relief they would get. So I doubt that anybody would put a civil case up for this. But they could. They absolutely could.
I think it's kind of goes to what you're saying on here. It goes, regardless of the point of view expressed, or to limit any existing legal remedies for such interference, provide exclusive criminal penalties or civil remedies with respect to conduct prohibited by this act, or to preempt state or local laws that may provide such penalties or remedies. or 4, interfere with the enforcement of state or local laws regulating the performance of abortions or other reproductive health services. That's on that part, but same thing kind of to do with the church or places of worship. And that's, it says intentionally injuring, intimidating, or interfering with, or attempting to injure, intimidate, or interfere any person by force, threat of force, or physical obstruction, exercising or seeking to exercise the First Amendment right of religious freedom in a place of religious worship, intentionally damaging or destroying the property of a facility, or attempting to do so because such facility provides. Yeah, that's. I think it can be criminal. And
I mean, do these people? My final thought is, do these people more resemble the brown shirts that are trying to set up a parallel police structure and set of laws and enforcement based on their own, egotistical determination of what right and wrong is, which is basically, if you don't believe the way I believe, you're wrong? Is it more like the brown shirts, or is it more like the civil rights movement, where actually the protesters and the people fighting for their rights were gathering in churches, but their targets were, the National Mall, Lincoln Memorial, White House, SCOTUS, right? During the civil rights, it was the institutions of power that they targeted. Yeah, again, what we see here is they're not targeting institutions of power. They're targeting churches. They're robbing people's. I saw a video of a guy steal another guy's car. There was a video of a counter protester that was stabbed. So what is this more like? Is this more like roaming mobs in Rome, or is this more like the civil rights movement that actually has a set of objectives that they're trying to achieve?
Okay, now going into the actual
without that objective being federal law doesn't apply in immigration.
Yeah, so going into actual case, it says in the case, went too far over, but I was trying to get to number one. It says by force, freedom access clinic force interest. Why is it? Let me go down a page. Oh, that's what I was trying to get to. I'm trying to get to the first one. So in the case of a first offense, be fined in accordance with this title or imprisoned not more than 1 year or both. And in the case of a second or subsequent offense after a prior conviction under this section, be fined in accordance with this title or imprisoned not more than 3 years or both, except that for an offense involving exclusively a nonviolent physical obstruction, the fine shall be no more than $10,000, and the length of imprisonment shall be not more than 6 months, or both, for the first offense, and the fine shall be not more than $25,000, and the length of imprisonment shall be not more than 18 months, or both, for a subsequent offense, and except that if bodily injury results, the length of imprisonment shall be not more than 10 years, and if death results, it shall be for any term of years or life. So that's the key word I was talking about, people. I was talking about the and or thing, is that we're looking at it. I think it's only if he's been charged on the previous crime under this act. And then also if anybody can prove they were injured, then it goes up. And what's funny is this is a federal offense, but it looks like it's a misdemeanor. It's a federal offense or a felony, but yet it's got like misdemeanor charges. 10,000 in 6 months. I mean, that's usually a misdemeanor.
Yeah, I mean those are also old. It was written in the 90s. So,
this is the last update. This is the last update of the public law for this for the FACE Act.
For most modern felonies, they have updated sentencing guidelines. I would say though, the thing that just strikes me as very, very interesting, again, even I want to compare this to January 6th. Okay. I don't care what you think about January 6th. I don't care if you think they were right or wrong. At least those people were protesting. And if you want to say they were targeting, okay, great. They were targeting Congress, the most elite and powerful group of people in our country. And then this group of people are targeting normal American. It's like that enough is evidence. So it's just everything they called the January 6thers. This is what they are. They were projecting that the entire time. And this is evidence of that. And it's a good thing they lost the 2024 election, because God forbid they won it, where our country would be today, because we wouldn't be having these battles. It would be lost. And 2028 is going to be the same battle. 2026 is going to be the same battle. It's going to be the same battle for the rest of our lives, because this ideology has deeply infected our society.
Okay. This goes to the one with what we're looking at. So it says relief in any action under subparagraph A. The court may award appropriate relief, including temporary, preliminary, or permanent injunctive relief and compensatory and punitive damages, as well as the cost of suit and reasonable fees for attorneys and expert witnesses. With respect to compensatory damages, the plaintiff may elect at any time prior to the rendering of final judgment to recover in lieu of actual damages an award of statutory damages in the amount of $5,000 per violation. So yeah, it says, if the Attorney General of the United States has reasonable cause to believe that any person or group of persons has been or may be injured by conduct constituting a violation of this section, the Attorney General may commence a civil action in any appropriate United States District Court. In any action under subparagraph A, the court may award appropriate relief, including temporary preliminary persons aggrieved as described in paragraph 1B. The court, to vindicate the public interest, may also assess a civil penalty against each respondent. So they can actually do a civil penalty against each person was there.
I mean, respondent could also apply to an organization as well.
Oh.
So I don't know if Don Lemon is working for any company or corporation, or if he was just acting as an independent journalist. But
here, I messed this up. Okay, in an amount not exceeding $10,000 for a nonviolent physical obstruction and $15,000 for other first violations. So if anybody was somewhat injured or bruised or pushed, that becomes violence, correct? I mean, if you put your hands on somebody, that's assault, period. I mean, if you spit on somebody, that is violent assault.
If you give someone the interpretation that you're going to be acting in a violent manner, if they have a reasonable belief, I might be a victim of violence based on your conduct, then yes, you don't need to act. If I go like this and I get ready to punch you, I don't need to land the hit for someone to say I was being violent, right? Because then at that point, whatever state you live in, whatever jurisdiction you fall under, then you could follow that set of state law as to how you can react and conduct yourself in the face of a violent threat, which is what I would be doing to you.
So in other words, we can look at probably up to $15,000 and 18 months per person that's in there. Now,
I doubt that they would blanket charge everyone there with violence. I doubt even Don Lemon would get charged with violence, but the mere act of charging, I don't know if you know what it's like when you are arrested and booked, but the bail process is miserable for most people. And the indigent, like veterans I worked with who were arrested for whatever issue, once they get in the system, their life is on hold. And unfortunately for the majority of people who participate in this protest, that's probably the position they'll fall in unless they do have an outside organization providing legal funds and relief for them. Don Lemon's probably not going to be affected. He'll probably, if he is charged and booked, he'll probably post his bail and take a bunch of pictures and try to profit off of it. So, you know,
all right.
I mean, what is really the legal remedy against him? I don't know.
All right. So I'm going to go ahead and get on to finishing my monologue since we're at 44 minutes, and we're going to go ahead and go on to the historic Supreme Court president case. All right. So Americans have been told for years that if election laws are changed in violation of the law, their only remedy is after the election has been corrupted. The Supreme Court just rejected that theory once and for all, finally. In Boss v. Illinois, plaintiffs were candidates who alleged that election rules were applied in a way that departed from what the law required. According to the Supreme Court, that allegation alone proves the plaintiff sustained a concrete Article III injury, even if they cannot prove those illegal rules will change who wins the election. That's huge. The court noticed something intuitive that nobody had acknowledged in decades. The injury suffered by a candidate isn't losing. It's competing in an illegal versus a fair contest, or the just the view of that happening, or of their honesty and of their integrity. And so that's what the integrity of it. So it should go without saying that candidates have a substantial interest in ensuring that an election is conducted fairly and that all ballots counted are cast in accordance with the law. And that's quoted from Robert C.J. This matters because it stops litigation chaos. Litigation can and should take place before ballots are cast so that rules can be made clear, not in the middle of an election where voters are left dizzy by shifting rules, which is Purcell and Gonzalez split in two sentences. The latter ruling specifically says late court changes cause diminished public confidence in the election process and sorely injure the conduct of elections or even people's belief or trust in the elections. So faith in elections must be protected or we lose our country before it's violated. Elections must be legal before they're run. And so this is what this case, and this is why I wanted to talk about this Boss v. Illinois case, is it was a case. A lot of people want to say, oh, this is an old case. No, this case was decided on January the 14th, 2026. This is not an old case. This isn't a 2020. This isn't rehashing 2020 elections, even though the fact that all those cases that the Democrats tried to charge Trump with for asking for ballots to be recounted or whatever, even though they claimed that he couldn't prove that the election would have been reversed or any of the other rules that affect it, those cases are now all null and void because of this new Supreme Court president. They can drop them because of the fact they're not going, nothing will go forward. And I'll let Joe comment on that. But if you were to try to take any of those cases forward now, the Supreme Court's going to go, well, under the new president, he had the right to do that at that time, and we're not going to charge him now. But the big thing is this Boss case, what it had to deal with is in Illinois, they were allowing that any mail-in ballot that was postmarked on the day of by the date of the election, even if they didn't receive it until 2 weeks later, would allow it to be counted. And the thing is that all ends up usually helping Democrats. And the question is if all these late rule changes and all these late mail-in ballots and votes coming in always go towards the Democrats, then use your common sense, use your critical thinking. How is there not some type of fraud going on? Because it should go either or. It's not something that should always go one way. And then my other issue with mail-in ballots, and I hope some of the people that were listening to my TikTok lives earlier this week that I could not speak about this on there, that I'm going to speak now. And this is the thing, is while there is no official proof or statistics, which finding statistics in political science is literally hard as near impossible because it's constantly changing. But when the only numbers that are coming in that the Brennan Center of Justice or the Wall Street Journal, whatever these companies get, come from the actual states that the ballots are counted in, the party controlling those ballots are running, how do you trust that they're actually telling the truth? How do you trust that they're going out and they're checking all the signature card on those ballots to the actual people live in the house? How do you know that they're actually going out to that person's house and making sure that person still lives there, or that person hasn't passed away, or they haven't sold the house, or they're not renting the house? Especially when you got states like Washington State, who even when people say, no, I don't want to register to vote, mail-in ballots, they still mail them the ballots. And Joe can tell you an instance where he could have voted in like 5 different states. Obviously he didn't because he didn't want to break the law. But that is the problem, is even though there's not necessarily physical proof of that fraud yet, it's common sense to come to the conclusion that there is large aptitudes for fraud when it comes to dealing with mail-in ballots.
Yeah, I'm not someone that's completely against mail-in ballots. I think you agree with this. There's room for certain cases where mail-in ballots need to be used.
Military,
right?
yeah.
Overseas. Yeah. And but those channels have existed before. But now this whole open up everyone's doing mail-in ballots. Like you said, I've had 5 driver's license in 5 different states as an adult because I was in the military. And I was just curious because I was living overseas. I voted in my home of record, which is based on what I read. That's how I had to do it overseas, being somebody who was in the military. But I checked to see if I could register in the other states. And I was like, okay. So I know I went to law school. I know plenty of rich lawyers that have property in multiple states, right? And if all you need is your address or an ID in that state, they could easily get it and they can easily vote. And there's no federal oversight. But just to rewind back to the case, right? So I see on the right, there's a strategy, right? Where, not just Trump, but other Republican presidents have been attempting to fill higher courts with right-leaning nominees, right? And they're pushing forward these novel cases, right? Not necessarily novel, but they're pushing forward these cases that already had precedent and then overturning the precedent as they did in this case. And the reason that they're doing this is because the way the legal system as a whole and the way that the legal education apparatus is structured is that it's the most polarized far left centers in our country. And I went to Berkeley for my JD, so that's the epicenter. And the legal profession, starting with law school and the LSAC down to the American Bar Association. If you say the wrong things, good luck getting a lawyer who's going to want to mentor you, getting a job at a firm, But so this also goes back to all the cases that were thrown out based on this precedent and we're not going to re-adjudicate 2020. That doesn't need to be done here. But when you understand that the majority of lower level judges, as well as the line and rank prosecutors, even public defenders, all vote blue because they've gone through this social programming ritual that is the legal profession, and they themselves are a parasite in society. The more laws they write, the more resources they can funnel out of actual, human, not just human capital, like actual these people aren't producing anything. All they're doing is meeting for 12 hours a day, talking about their next meeting, and they have no faith. They have no faith or belief and trust in the Constitution. That's why, the idea that the Constitution is a living document, I understand that argument because, yes, society doesn't always match what the Constitution says, and obviously it can be amended, but it doesn't mean you can just rule whichever way you want based on your politics, which unfortunately we see that from left-wing judges, we see that from right-wing judges. But as a whole, the way Trump has structured the Supreme Court and the people he's nominated so far, they're doing a great job of, kind of sealing up, rather than getting in the trenches and engaging these. You're never going to have 50% of lawyers supporting Trump. It's just not going to happen. Why? Because many people who are attracted to this career are a little narcissistic. They're a little egotistical. And when they hear Trump speak, they think, this guy's dumber than I am. How can he be my leader? But that applies to every other avenue across they think they know better, and therefore they have the right to decide for the rest of us. And this is exactly how they adjudicate in the position when they're judges. And it's exactly how they prosecute when they're prosecutors. That's why you see attorney generals in very, very far left cities not choosing to prosecute certain crimes, right? And yet they'll throw the book at other people. And that is the opposite of justice. That's a two-tier justice system. When you're rounding up everybody on January 6th and sending them to jail for years and, hammering them with laws and using them in new ways just to engage in lawfare, and then you're this is why they're doing it, is because on the grand strategic chessboard, they're losing and they know it. And therefore they want to destroy and burn down the system. They want to stack the Supreme Court. And kudos to the Trump team and to SCOTUS that this came through, because you can definitely see these chess pieces moving and posturing and just prior to the midterms. I think you agree with that, right?
Oh yeah. And what I think is funny is how even Amy Coney Barrett, even though she currently has standing, her in her own words, she says Congressman Bose has standing because he suffered a judicial pocketbook injury, not because of his status as a candidate. And she says standing must rest on on concrete harm, not political status. She stresses that Article 3 requires actual injury, not abstract interest tied to elections. But the problem is with that thinking that Barrett has got versus what all the other the majority of the justices, I mean, this was an 8-1 7-2 or 8-1 decision, is the fact that yes, that might be true, but the problem is by the time you get past the election, you only have a small amount of time from the time the election's over till the time that they actually have to certify. I mean, we saw that happen in Bush v. Gore. I mean, we saw that in Bush v. Gore, Florida changed election laws like right in the middle, close to election day, and almost right at election day, which caused all the stuff. And then because they couldn't settle everything before the certification before a certain date, December, the Supreme Court ruled that, okay, we believe it was Bush that won, and he got certified. Now, if maybe this law had been in place then, who knows if Bush really would have won or not, because those changes to the election law would not have been allowed, and Florida would not have been allowed that late into the game. And see, that's what we see happen here is we've seen all these election law changes, especially with these mail-in ballots of, we'll count them up to 2 weeks after election day. It's ridiculous. There's no way you count what's been there on election day. I think the solution is okay, you know what? If you want to make sure, take away, like we said, mail-in ballots, except for military and maybe people who can't get to a facility to vote, And then what you do is lengthen the time of the early elections. Give people more time to get to the polls instead of give more, make election and make early voting start a month and a half, 2 months early instead of a couple days early. That way you're not having to rush right on poll day and you're not messing that vote and you're not getting it because because the mail-in ballots there is so much right for even, I wish I could have found the video, but there was even Democrats who literally said back in the early 90s that mail-in ballots were ripe for fraud because due to the fact that people can easily, there's no way to prove who's signing it. And then the other law, like Minnesota has this stupid law that one person with an ID can vouch for 8 people stating that they are legal residents of the state and legal citizens of the United States to vote without ever registering to vote. And that's another law. It's like, since when do we trust the honor system? Since, there's a threat of being in trouble or getting a felony. Yeah, but most people don't think they're going to get caught. That's why they do this stuff. They're thinking, nobody's going to investigate this. I'm a Democrat. This Democratic Party, Democrats are in control. They're not going to investigate this. They're not going to go after this. And they're right. They're not going to, because all the Democrats care about is winning. The only major, the others, other than getting the SAVE Act passed now, so we have requirements of verified voter ID and verification of citizenship to vote. The one other law, we need to get Purcell reversed. Not Purcell, but Crawford v. Marion County reversed, because that was the biggest BS there. Because Crawford v. Marion County caused, which one? No, it wasn't Crawford v. Marion County. It was a Roberts Court decision that made a certain, that really screwed up the voting laws and the voting regulations for.
I think it is Crawford in Indiana.
Well, no, that one was just,
established such requirements that do not violate the Constitution, find that the state's interest in preventing voter fraud and promoting confidence in elections outweighs the slight burden placed on voters.
Well,
so that's actually in favor.
Good. Well, yeah, it wasn't Crawford. Crawford was in favor. Purcell said that it was too close to the date. I'm trying to remember the name of the court. I'm trying to remember the name of the one for the court one that was to deal with that dealt with it. It had to do with the Roberts Court. It was back in like 2006 or whatever, early 2000s. And it made something unconstitutional or whatever that seriously affected the voting. I can't think of it right now. But yeah, it had to do with mail-in ballots, and it just totally destroyed everything to do with that. And we need to get that fixed. I can't remember the exact case that it was. I wish I could to talk about it here.
Where year was it from?
It was a Roberts decision. And I can't remember. No, actually, it was not. It was Trump's first term, I think. Actually, maybe it was 2017. It may have been back in 2017. It had to do with, I can't remember the exact rule it had to do with, but yeah, it screwed up. Is it a
Republican National Committee versus Wetzel?
That might be it. Look and see what's on that.
Mississippi, they had to argue that state law conflicts with federal statutes, uniform election day, plaintiffs have to enjoy state officials from enforcing the post-election ballot deadline. So that looks like it is it, because that would be
yeah, it had.
So they say that's where the court said casting and receipt of ballots, and that the election is not consummated until all ballots are received. So yeah, I think that is the case you're discussing. But that is some legalese. That is some like you're jumping through like circular logic to right. Okay, it must be cast by election day, but the election process is not over until everything. It says must be received by election day, but election day is not over until all ballots are received. So yeah, that's not going to hold up.
Yeah, and that shouldn't be, because I'm sorry, it should, whatever, you can't, because then that leaves the fact of stuff coming in past election day and past that time. And that's what I'm saying is we need to extend the voting time because that leaves just too much opening for voting. And I think there was another one that had to do with ballot boxes or something like that.
So I'm not seeing any SCOTUS cases that have ruled on that. So those are all circuit court of appeals decisions. So those would be outside of that specific circuit. You know, you could those might affect other circuits, like say, hey, this circuit's ruled on this, but any circuit could rule against that within their own circuit. And then once that conflict emerges, then it would probably be brought before the Supreme Court to decide what the actual federal precedent would be in that in that situation.
No, it was okay. Was it Shelby County v. Holder? No, it wasn't Shelby County v. Holder because that was actually in benefit. That had to do with the redistricting disputes and stuff. Okay, I'm gonna get it to give me voting SCOTUS cases where Roberts wrote the court's opinion. I'm trying to get it because I forgot to get this one. I'm trying to get I'll bring my solo up. Sorry, guys. I'm just trying to bring this case up because I mentioned it, looked it up the other day when I was doing a live, and I can't remember exactly which one it was. So I'm trying to get it up. And I know it was more than just Shelby County v. Holder. And there was a big one of having to do with federal oversight or something. And it was a pretty big case that really affects. I might have to bring it up another day because I can't remember it. I know it was around had to do with voting rights, core voting election law, opinions by Chief Justice Roberts, restored primary state control over election laws, absent modern congressional findings, cornerstone federalism. Okay. All right. I'll bring you back up. Yeah, I'm going to just have to find it later. I can't remember where it wasn't Shelby County because that's avoid ruling directly unconstitutionally, but sharply question pre-clearance. So that wasn't it. And then it wasn't Allen v. Milligan because that was to deal with dilution standards. Rucho v. Common Cause, claims of partisan gerrymander are not justiciable political questions. Yeah.
Save that. Make that a talking point next week.
Yeah. I'll bring it up for another one.
Do a blur.
Your mother knows. Yes, you should be. You're right. The problem is like in Illinois, they made a law where yes, they don't have to be received by election day. It states that they have to be postmarked by election day, and Illinois will accept them up to 2 weeks later. That is what Bost was challenging. Now, of course, the merits of the case were never challenged because the state level court, the local district court, and then the Seventh Circuit Court all denied that Bost had standing to challenge that case. So now that the Supreme Court has ruled that Bost did have standing for that case has been remanded back down to the lower courts for the merits of the case to be argued. Now, obviously, we can probably expect the state court, the district court to rule in favor of Illinois and against Bost. It's probably going to have to make it back to the Supreme Court case. But under the one case that he just mentioned, the question is, will it make it back to the Supreme Court before it's too close to the election to be considered too late of a change? That's the question. That's another thing is we need all Republican candidates in Democratic states or swing states. If you feel like there are bad and people on this live, we got 385 right now. If you live in a state where you feel like your voting laws are screwed up, whether it's would deal with mail-in ballots or other stuff that you feel like they're given loopholes where it comes to certifying the vote or anything like that, make sure you write your Republican congressional candidates or Senate candidates and tell them to file a lawsuit on it because now is the time. We are before primaries. They can challenge it for the general.
Let me tear this out here. So let's take California for an example. All right. 16 million total ballots. 2024, 90% of California voters used mail-in ballots. By the end of the first week, over 5 million had not been counted. So, and then they only threw out 122,000 ballots for a state the size of California. Come on. 122 out of 16. All right, let's do the math there. Let's see. Calculator. 111,000 divided by 16 million.
Or my question is how 317,000 votes in Georgia were never signed to be verified as clear, but they said somehow that didn't make them invalid.
So in California in the 2024 election, not even 1% were thrown out. It was not even 1/10 of a percent, 100%. It was 0.006% of ballots were thrown out. Now, that doesn't strike me as not fraudulent, and it's common sense. And this is why they're fighting so hard in so many different, areas to uphold the way they're voting in California and in Illinois and in Massachusetts and now in Virginia, because don't pee on my leg and tell me it's raining, right? It's common. If we really wanted everybody to vote, let's vote by cell phone, right? Or, hey, there's a reason we schedule school board elections on days that the regular vote, like election day, is not, because we know the people that care about school boards are going to go and vote, therefore they should. So it's not this idea that we need to make voting this automatic, easy process, right? We want people who actually have a vested interest, but also are eligible to vote, which I'm sorry, but California throwing out 0.006% of their mail-in ballots. I want to compare that to every other state, because that's an extremely low number that they didn't certify.
Oh yeah, and that's the crazy thing about
that's
it.
Going to be state by state, your mother. That's why if you looked right on election day, Trump was up by 15 million votes, like right at the election, and then he ended up by winning by 2 million, because again, that 6 million of those votes came from California.
Your mother knows I do not disagree with you, but in the state by state laws are different, and states have the right to set their own laws to a point unless somebody challenges it. And in the state of Illinois, that is not the law. I agree with you. That should be the law, that ballots that are postmarked on or before election, if they are postmarked on election but not received, they should be rejected. But that's not what Illinois does. They accept the ballots up to 2 weeks later. So I totally agree with you. I'm not arguing that. That's what I'm saying is people need to pay attention to the significance of this case, because if now we get our senators to nuke the filibuster and push out the SAVE Act, and you have this ability where now states will know that they can't sit there and try to change laws in the middle of an election or right before election, because to try to skew an election to their party to benefit them and benefit ballot harvesting and all that, because they want to win, because they know that the Republican candidates can come in and challenge it. They don't have to wait till after the election's over and then try to some miracle way prove that there would have been actually enough votes due to that rule to cause a change in the election. Now they won't be able to do that, because that's what it was before. And that's why Trump was getting charged with all of those interfering with election charges and stuff, is because they were claiming that, there was no proof that even if there was cheating in those states, that there was enough to actually have changed the outcome of the election. And so he had no right or standing to request a recount. But that's what this changes, is this gives Article 3 standing to any candidate. So now you have the right to ask for a recount no matter what, or you don't even need to wait till a recount. You can now, if you believe some state or local rule affects the ability or is not legal, you can challenge it before you get to the election. Now, obviously, I don't think they're going to, if the Supreme Court hears it 2 days or 2 weeks before the election, that's not going to work. But if you're challenging it on the general election, not the primaries, and you get the case to the Supreme Court by, I don't know, June, July, maybe August or September at the latest, then they'll still rule on that one, because that gives plenty of time to change it before any type of early voting or your voting day starts, because the deadline will probably be somewhere around right before early voting.
I'm on mute.
You're mute.
Yeah, that's part of what the purpose of the podcast is that we're highlighting specific legal issues that you may not be aware about, or you might have, maybe a pop culture understanding of, and then we're discussing the ins and outs. Dr. Hill finds the cases or the topics, and then I'm providing my insight as somebody who has a JD. He's got a law and public policy, but we're highlighting this to you because this is one, it's changing. It's obviously a new precedent, and then two, this is an issue, and this is not just an issue on the left or right. Going back to 2000, like he talked about earlier, Democrats said Bush stole the election. Then 2016, Hillary said Trump stole the election. 2020, Trump said Biden stole the election. 2024, you have election deniers. So there's no intellectual consistency or to it. It's, at least I will say on the left, right? When Trump wins, he stole the election, but
okay, so
don't get me started. We don't want to re-adjudicate that, but
yeah, if we get to Boston, Illinois, midterm impact, states with extended receipt deadlines, e.g., postmarked by election date, are now litigation targets. Campaigns will aggressively monitor late ballot batches. Margins may be frozen earlier, reduce and prolonged ballot drip narratives that undermine confidence. Another, if you look at the Bush v. Gore principles, are backed at center stage. Midterm impact, courts will be far more reluctant to allow non-uniform recount standards, ad hoc ballot interpretation, or selective curing. Any county-by-county variation in ballot handling invites equal protection challenges. Expect faster injunctions if election officials deviate from statutory procedures. This creates strong incentives for uniform enforcement, not discretionary flexibility. Voter ID laws remain constitutionally secure. And then when you come to reducing post-election chaos, increase in legal discipline is taken together. These cases incentivize early rule clarity, legal judicial improvisation, less judicial improvisation, more predictable certification timelines, fewer late night rule changes, fewer emergency injunctions after ballots are counted, and narrower space for activist litigation aimed at altering outcomes retroactively. And the funny thing is the most of these, it undermines the confidence in the election. And one part is that it strongly favors jurisdictions that lack rules in advance and disadvantages states that adjust advanced procedures. So that's where we're getting at here. Is this is going to be a better bill overall for the everything that goes. And I was going to read one more thing, a couple lines that it said, and this was going from the concept of the ruling. So this ruling explicitly discourages count first, litigate later scenarios that damage public confidence in 2020. And you also, this benefits Republicans by reducing uncertainty windows that historically favor Democratic ballot harvesting operations and limiting late counted ballots that often break disproportionately left. And that's, like I was saying earlier, is there's something going on when late ballot counting disproportionately goes left. It should never always be one way. It should maybe one year be left, the other year be right. But for late vote counting to go to disproportionately left, that makes you have to use your common sense and your critical thinking skills to say, hey, something's fishy here. Something's not right here. And that's what we're getting. I mean, so
I agree with you.
Yeah, so
I gotta start heading out.
Oh yeah, we're over an hour anyways. So all right, everybody. I appreciate y'all.
Final thoughts?
No, I'm gonna just give the closing, and then you can go ahead and step out. And we're way over we're already an hour and 15 minutes anyway. So you have a good night, and maybe I'll see you on TikTok later. All right, everybody. Thank you for tuning in tonight to No Kings on the Hill, episode 17 with Dr. Hill Law and Joe St. Clair. I just want to say thank you for tuning in. Also, we are live every Wednesday night at 5 p.m. Central, 6 p.m. Eastern, 3 p.m. Pacific Standard Time. We are also with the Patriots Prayer Network, so you can check us out there, or you can check us out at my website. Let me get the banner back up so y'all can see it. It is www.nokingsonthehill with drhillaw.com. There you can on the homepage has all the links to all my different socials. Please give the show a follow there. And also you can see all of our current and previous episodes that we have that are on the website too, and any blogs or weekly blogs that I've written. And as for, we look forward to seeing you by this next week. And also please join me on my TikTok lives during the week. Really, it would be beneficial. We appreciate y'all commenting and engaging in the show. If y'all would like us to cover any certain subjects or anything like that, please either send us a message on the website or contact me on my TikTok page, which, like I said, you can get to that link on my TikTok on my website, or it's at Dr. Hill Law. And look forward to seeing y'all next Wednesday. And y'all have a great weekend and a good night. And thank you.